State of Tennessee versus Kenneth George Arnold.
Mr. Fallow, proceed.
Good morning, Your Honors. My name is Carson Fallow. I'm an assistant public defender in the 11th Judicial District of Tennessee, and I represent Mr. Arnold in this matter. As an initial matter, Mr. Arnold and I, if it pleases the court, would like to waive any oral argument on the insufficiency argument in my brief, and instead focus this morning on our second argument, which is that the trial court in Mr. Arnold's case abused its discretion specifically on the sexual battery by an authority figure charge when it sentenced him to consecutive sentences on that charge, as well as the other two, under TCA 4035-115B, because that particular statute cannot be applied to Mr. Arnold's sexual battery by an authority figure without doubly enhancing his punishment on that specific charge. Double enhancement in this case occurs because the facts and circumstances necessary to convict Mr. Arnold of aggravated sexual battery by an authority figure are the same facts and circumstances needed to enhance his punishment under the multiple conviction statute. So just as an initial note, the standard of review in this case is abuse of discretion with a presumption of reasonableness, which is obviously a high standard to overcome. So I would just note briefly that the trial court itself during Mr. Arnold's sentencing hearing expressed trepidation about applying 115B5 to Mr. Arnold's case, specifically because of this double enhancement issue, essentially inviting the court to evaluate his discretion, or the appellate court to evaluate his discretion. So I'd like to just briefly do a compare and contrast of the elements of aggravated or of sexual battery of a minor by an authority figure, as well as the elements of that would allow enhancement under multiple convictions under 4035-115B. And then I will conclude by briefly addressing State v. Massey, which is a case that the state relied on essentially to argue that the argument about double enhancement is entirely irrelevant due to the fact that 4035-115 does not carry the same prohibition in its language that 4035-114 does as it relates to the issue of double enhancement. But going back to the elements of sexual battery of a minor by an authority figure, there are two essential elements of that offense that require the same showing of proof as 115 or as 4035-115B. The first is that the victim was at the time of the offense 13 years of age older, but less than 18 years of age. And the language in 115, and that's the language in sexual battery of a minor by an authority figure. The language in 115B5 is more simple than that. It's statutory offenses involving sexual abuse of a minor. And while the language there is slightly different, I think it's important to note that it's asking for, in Mr. Arnold's case specifically, using the exact same evidence, which was that in Mr. Arnold's case, the victim at the time of the offenses was between the ages of 13 and 16, and then which would fit into the statute. And then that same evidence is also used to demonstrate that the victim was a minor. And so I understand the language is different, but it goes back to the fact that it's the same facts and circumstances, the same showing of proof is being used to both convict someone and then ultimately and doubly enhance their sentence. The other essential element of sexual battery of a minor by an authority figure that matches closely the requirement of proof under 115B5 is that the defendant was at the time of the offense in a position of trust or had supervisory or disciplinary power over the victim, or otherwise had custodial or parental authority. Now, in Mr. Arnold's case, that was established at trial, both through testimony regarding the nature of their relationship, as well as a showing of proof that he was her stepfather and was a custodial or parental authority figure. And once again, going back to 115B, it's also, again, an issue of the language in 115B is admittedly much more broad. It's simply that the relationship between the defendant and victim are victims. But again, I understand, and I will address State v. Lacey in regard to the fact that the language is slightly different between the statutes, but it goes back to the fact that it's the same showing of proof. It's the same evidence that was used to convict Mr. Arnold of sexual battery by an authority figure for the state to prove an essential element of that offense is also being used to allow him to be consecutively sentenced. Finally, in terms of comparing the statutes, I'd like to just address the fact that admittedly, there are two other elements of the 115B5 that are not essential elements of sexual battery of a minor by an authority figure. And that's the statutes, one of the elements that you can use to prove 115B5 is that the abuse was ongoing in nature. As well as the time span of the defendant's sexual activity and the after effects of that sexual activity. And while that's not an essential element of sexual battery of a minor by an authority figure, I would again go back to the fact that we're using the same, there was evidence presented at trial used to demonstrate the relationship between the parties that established an ongoing sexual relationship. That ongoing relationship was used at trial as one of the things to convict Mr. Arnold, as was at trial testimony regarding the effects of the abuse on the victim. And so while I understand, and this does take me nicely to Lacey, that we're talking about a situation in which the essential elements of the offense don't perfectly match up with the essential requirements of 115B5. The issue is that it's essentially a distinction without difference. In State v. Lacey, the Court of Criminal Appeals held that a defendant's sentences for aggravated child abuse and felony murder arising from that abuse were not doubly enhanced by use of aggravating factors because there was a sufficient distinction between the age of the victim element and under the aggravated child abuse statute and the aggravating factors under the relevant statute in that case. But I would argue that if the goal is to demonstrate, if the underlying purpose of both statutes is to punish someone for misconduct against a minor, what we're doing is making a distinction without difference. In other words, it's saying in Mr. Arnold's case, 13 to 18 years old is different than sexual abuse involving a minor. While it's true that there are circumstances where Mr. Arnold wouldn't have been enhanced, say if he was convicted of a different offense that just said minors and not, or if it said, for instance, anyone under 18 instead of giving a set age range. But the fact of the matter is that Mr. Arnold was convicted of sexual battery against a minor, and then the victim's status as a minor was then used to enhance his sentence after the fact. So finally, I would like to address just a couple of the state's arguments. First of all, while it is true that 4035-115 does not carry the same language prohibiting double enhancement that 4035-114 does, I think that the issue that language doesn't exist is precisely why the trial court was concerned over an issue of double enhancement, because while the majority of the various factors under 115 that could cause that could give rise to consecutive sentencing don't actually create a double enhancement issue, 115B5 specifically does. I would argue in any situation in which the defendant is convicted of a crime that's sexual in nature and against a minor. Finally, just to briefly address Massey, and it goes back to what I just said about 114. While I understand, I would agree the state's position is correct with how 4035-115 is written at the moment and how and the state's correct in its interpretation of Massey, my response would simply be that regardless of whether the court in Massey essentially decided the question without delving into whether or not 115b5 should carry some kind of prohibition against double enhancement. They simply looked at the statutes and said, well, this double enhancement issue, it's in 114, but it's not in 115. So we don't actually need to make a decision on it. And so I think what Mr. Arnold would ask the court this morning would be to simply consider whether 4035-115b5 should have that prohibition. Thank you.
All right. Thank you. General Law.
Good morning, Your Honors. May it please the court, Courtney Orr on behalf of the state. Simply put, there is no double enhancement when applying the consecutive sentencing factors. Double enhancement and the case law relied on by the defendant in his brief refers to using the elements of an offense to enhance the sentence for that single offense. So that would be using the fact that the victim was a minor in this case to enhance the single sentence for aggravated sexual abuse aggravated sexual battery by an authority figure. That is simply not what the court does when imposing consecutive sentences. Instead, as the Tennessee Supreme Court stated in State versus Allen, 259 Southwest 3rd 671, the court's decision to require separate sentences be served consecutively in no way increases the penalties for individual crimes. Consecutive sentences are separate punishments for different offenses, and two sentences do not become a single sentence by virtue of their running consecutively. The case law about double enhancement and the argument advanced by the appellant today is simply irrelevant to the question of whether the sexual abuse, two or more convictions for sexual abuse against a minor may be used for sexual battery by an authority figure. It is not double enhancement to apply that consecutive sentencing factor to these offenses. Under either a constitutional argument, which is what State versus Allen addresses, admittedly in the context of Apprendi, but here I believe it is still instructive. There's no constitutional concern about using the elements of offense within the consecutive sentencing considerations. And additionally, as the Supreme Court stated in State versus Lane, there's no statutory concern because there is no prohibition in Section 115 about using the elements of an offense when considering the consecutive sentencing factors. And as this court held in State versus Massey, specifically, there is no concern about using the multiple sexual offenses against a minor consecutive sentencing factor to run multiple convictions for aggravated sexual battery by an authority figure consecutively. Simply put, the defendant's argument about double enhancement is not relevant and does not apply to consecutive sentencing. And the court properly exercised its discretion when setting partial consecutive sentences, in this case for an effective 13-year sentence. Unless there are any specific questions about the case cited in my brief, and I'm happy to file a letter of supplemental authority with State versus Allen as soon as we're done here today. I ask that you affirm the judgment of the trial court.
Very well. Thank you for your arguments today in this case. The court appreciates that. And that concludes the argument in this case.
The Honorable Court of Tennessee is now in recess.